This was a comment that was left on my video about Kim Kardashian and the fight over her knockoff Donald Judd furniture. My post was about how I thought the fight over whether Kim Kardashian could do a tour of her office and post it on social media with the knockoff Donald Judd furniture in it and refer to it as authentic Donald Judd furniture in her video. In my opinion, that the outcome of that case could really set the standard for what you could or couldn't share on social media about your life. This commenter thinks that's a misrepresentation. I actually don't, because I think the whole point of the case is whether what Kim Kardashian did would constitute promotion or not. From some of the other comments on the video, a lot of you think everything Kim Kardashian does is promotional, and that's fair. But I wanted to talk about this comment for another reason, and that is that what caught my attention in this comment was that the person said that you couldn't use Donald Judd furniture in promotional or marketing materials after you bought the chair. And the reason that caught my attention is because copyright law has something called the first sale doctrine. And generally speaking, what the first sale doctrine means is that you can use the copyrighted thing that you purchased. So the most talked about instances of this are when somebody buys a copyrighted book and they resell that book, even though they don't own the copyright to the book, they're able to resell the book without permission from the copyright holder. So I thought that the first sale doctrine probably would allow somebody to display a sculptural work like a Donald Judd chair and would allow for it without it being copyright infringement. But I had never had a case actually where the first sale doctrine applied to a sculptural work, so I looked it up. The first sale doctrine is codified in the copyright statute, and when I read it, I learned something very interesting, which is that while the first sale doctrine does apply to sculptural works, like a Donald Judd chair, there's actually a limitation in it. And that is that you can only display the sculptural work under the first sale doctrine if you are displaying it in the location where the viewer is. So to me, what that means is that you could display the chair in your office and people who come to the office can see the chair, and that's not a violation of the copyright statute. What I didn't see in the first sale doctrine is that you could display the chair on the internet where the people seeing it are not actually in the same location as the chair. Now, that's not to say that, in my opinion, you cannot post sculptural works in videos or on your website without permission of the copyright holder, because I think there are a lot of other doctrines in copyright law that would allow for that under certain circumstances. But it is to say that my initial thought, which is the first sale doctrine probably allowed for it, was actually incorrect. And the first sale doctrine looks like, just based on the statute, doesn't allow for it. Actually looked for cases too where the first sale doctrine might have been applied to sculptural works, and I didn't see anything that really talked about this particular limitation in the code. So I wanted to post this to clarify the issue and also to say thank you to the commenter on this, because you caused me to learn something new. I'm Tammany. I'm an IP attorney with 20 years of experience, but even I learn new things about the copyright law.